Welcome to The Explainer. We're going to jump right into a really high-stakes legal battle out of Idaho today. It all comes down to a wild question. What if you could win a court case simply by making it impossible for the court to even rule on it? Yeah, this is a fight that could seriously change the game for homeowner rights all across the country.
And this whole story, it really hinges on one single critical date, March 20th, 2025.
Okay, so picture this.
On this one day, a homeowner named Jeremy Bass is, for all intents and purposes, in two places at once. He's at the courthouse, literally filing papers to stop his eviction. But at that exact same moment, back at his home, a home he's lived in for 20 years, a force of 7 sheriff's vehicles is pulling up to execute that very eviction. I mean, how does that even happen? Let's get into it. And that right there, that's the heart of this whole conflict. We are talking about the strategic removal of Jeremy Bass from his home while his case, challenging the whole thing, was already active and under appeal before the Idaho Supreme Court. So what was on the line for him? The stakes were huge. We're talking an estimated $305,000 in home equity. You know, the value he had built over 2 decades. Just gone in an instant. Now look at this timeline, because the timing is just everything here. So Bass has his appeal pending. Then on March 20th, while he is literally at the courthouse, the other side executes what's called a writ of restitution. That's the official paper that says you can physically take the property. He immediately files emergency motions, of course. But just a few days later, the plaintiffs turn around and file to dismiss his entire appeal. The reason? They claim the case is now moot. And Bass argues this was no coincidence. This was a deliberate strategy to create what lawyers call a prejudicial fait accompli, a fancy way of saying they created an irreversible situation just to tie the court's hands. So let's talk about this core legal tactic, this maneuver. It's a concept called strategic mooting. So what does it even mean for a case to be moot? Well, in simple terms, it's when a court just says, hey, there's nothing left for us to decide here. The central argument is over, so any ruling would be totally academic. It wouldn't change anything. Like if you were fighting an eviction, but then you just moved out and gave back the keys, the case would probably be considered moot. And this is the playbook that's allegedly in use here. Step 1, a homeowner does what they're supposed to do. They file an appeal. Step 2, the other side races to enforce the judgment and take physical control of the house. Step 3, they then turn to the appeals court and say, hey, he doesn't have the house anymore, so the issue of possession is settled. And boom, Step 4, they ask the court to just throw out the appeal, which means the legality of the original foreclosure never, ever gets reviewed. And Bass himself says it best in his own court filing. He argues that if you let someone get away with this, you're basically creating an incentive for people to deliberately sabotage appeals. You're rewarding them for creating their own game-over scenario just to dodge the justice system. But this fight is not over. Not by a long shot. Bass launched a really sophisticated counterattack, and he built his entire defense on 3 key legal arguments. First, he says the case is anything but moot. Why? The money. He's saying, look, even if I don't have the house, I'm still out over $300,000. That is a very real, ongoing financial injury. And he points to past rulings from the Idaho Supreme Court that say these kinds of financial claims are a live controversy a court can still rule on, completely separate from who physically has the property. His second pillar points out that the law actually has safety valves for situations like this. They're called exceptions to mootness. He says 3 of them apply here. 1, the financial consequences. 2, this is a tactic that is capable of repetition, yet evading review, which is a huge one. It means if they can do it to him, they can do it over and over to other people. And 3, he argues there's a major public interest in protecting the entire appeals process from being gamed like this. His third pillar is maybe the most fundamental of all. He's arguing that the Idaho Supreme Court has what's called inherent equitable authority. He's basically saying, you are the highest court. You have the power to make this right, to undo a wrongful act that happened while this case was under your review. And this table just lays the whole fight out perfectly. You've got Bass arguing for what's actually just and fair, pointing to the money in the court's power. The plaintiffs, on the other hand, are sticking to one narrow, technical point. We have the house, game over. But check out that last row. Bass is citing numerous official Supreme Court cases. The plaintiffs, they're leaning on a single, unpublished lower court opinion. In the legal world, that's a big difference in firepower. So at this point, you might be thinking, okay, Fascinating legal drama, but it's one case in Idaho. Why should I care? Well, let's zoom out, because this is where it gets a lot bigger. It's a completely fair question to ask, and the answer, believe it or not, has some pretty serious implications for property owners absolutely everywhere. Here's why. If this strategy gets the green light in Idaho, it becomes a roadmap. It becomes a playbook that can be used nationwide. It basically gives a how-to guide on short-circuiting a homeowner's right to an appeal. It would make it that much harder for ordinary people to challenge foreclosures and would prioritize procedural speed over the fundamental right to due process. And just to add another layer to this incredible David versus Goliath story, Bass is representing himself. The term is per force pro se, which means he was forced to because, get this, over 120 law firms turned him down. And yet, here he is, on his own, putting together this incredibly sophisticated legal challenge. It is truly remarkable. So, everything now lands squarely with the Idaho Supreme Court. And they are facing a decision that's going to have massive consequences, not just for Jeremy Bass, but for the very integrity of justice in their state. The court really has a few ways it can go. It could dismiss the appeal, which would basically endorse this whole strategic mooting tactic. It could find that the exceptions apply and let the appeal move forward. It could even use its authority to restore possession of the home to Bass. Each of these paths sets a huge precedent for that ongoing tug-of-war between procedural rules and actual substantive justice. As one legal scholar put it, this case is a critical test of whether equity truly abhors a forfeiture. That's an old legal idea that means the system of justice should hate to see someone lose everything over a technicality. This case is going to show what our system really values more, sticking to a procedure even when it's being used as a weapon, or finding a way to do its right. And that really leaves us with the fundamental question at the heart of all this. Should a faster, more clever strategy ever be allowed to defeat a person's basic right to an appeal? The answer from the court is going to echo far beyond the borders of Idaho. Thanks for joining us.